Welcome. My name is Suzanne Griest, and I'm an attorney at MPL law firm who specializes in family law. And I'd like to talk to you today about gifts and inheritances. A common question that I get from my divorced clients is, what about the gifts or inheritance I got from my family? Is my spouse entitled to any of that money? The simple answer is yes. The more complex answer is it depends on what the spouse did with the gift or inheritance. And remember that in equitable distribution, that is the process of dividing the marital assets. Gifts between spouses are marital. So, for example, if I gave my spouse an anniversary ring, that's a marital asset. Engagement rings, though, are non-marital in Pennsylvania, as they are considered a gift in contemplation of marriage. The important thing is, though, gifts from anybody else, from third parties, are not marital. However, it is subject to this caveat. What did the person do with the gift? So, for example, if wife received a check at Christmas from her grandmother in the amount of $10,000, what she does with that gift is critically important. If wife puts it into a savings account in her name alone, then only the increase in value or the earnings on the money is considered marital and in the pot to be divided. The increase in value is determined from the date the gift is made or the money is inherited to the date of the parties' separation. If wife, however, puts the money into a joint checking account or buys a vehicle in joint name, then she has gifted the entire amount to the marriage and it is considered marital. These same rules apply to inherited money received. Please remember that the possibility of inheritance doesn't count. So I often hear statements like, my wife's going to inherit $1 million from her parents when they die. Well, that's speculative, and it's not a marital asset or a factor in equitable distribution, because wife's parents could end up using all their money to care for themselves in a nursing home, or they could spend all their money during their lifetime. But if the parents created a trust with the funds and wife's a beneficiary of that trust, and she's clearly going to get some of that money at some point, then that's a different story. It could be considered a marital asset. The real answer that clients want to know, however, is how will this affect the distribution of the marital assets? Well, if the gift or inheritance was not combined or commingled with other joint assets, I've already stated that it's merely the increase in value of the gift that's in the pot for consideration and division along with all the other assets in equitable distribution. If the gift or inheritance was commingled, the division then gets a little bit trickier. The most common example is when a spouse inherits money and uses it to purchase a home in both parties' name or puts it into a joint bank account. I have a case now where a spouse was gifted over $800,000 from her father over time. It was all placed in a joint investment account, and in fact, the parties have been living off of this money for years. Husband is now arguing that he should get half of this money. I'm arguing, on the other hand, that he should get less than half, because the only reason they have the money is that it came from wife's father. The courts in York County generally look at when the gift was made and how close it was to the date of separation. If the gift was made close to the date of separation, the gifting spouse will end up with the lion's share of the gift. If the gift occurred earlier in the marriage, the argument for wife to get the lion's share gets diluted over time. Some counties in Pennsylvania, however, use the vanishing or diminishing credit doctrine. And this focuses on the length of time that the contributed property was held jointly and not necessarily the overall length of the marriage. So typically, the non-marital contribution will become marital at the rate of 5% per year. For example, if wife received $20,000 in inheritance from her aunt, and she used it to purchase a marital residence in joint names, and let's say the parties own the property for 10 years, then 50% of the $20,000 inheritance would be considered marital, or $10,000. The other $10,000 of equity in the property gets distributed directly to wife. Now, if the parties, on the other hand, were married for 20 years and held the property for 20 years, then there would be no credit given. Remember, the non-marital estate of a spouse is still a factor to be considered in equitable distribution. So the fact that one spouse has $100,000 in non-marital assets and the other spouse has nothing might impact on how we divide the assets of the parties in the marital estate. My best advice to you or the client is to keep the gift or inheritance separate. Or consider contacting an attorney and having a postnuptial agreement outlining the parties' rights to the gift or inheritance, especially if you intend to consider making a joint purchase. Other advice is that if you are single and getting married and have a substantial assets in your own name, then consider contacting an attorney and having a prenuptial agreement prepared. Thank you. And if you have any questions or concerns, please feel free to contact me or some other attorney at MPL Law Firm.